Hello, everyone. Welcome to U.S. Immigration Info. With January now underway, some immigration changes that were discussed late last year are no longer just guidance or proposals. They are active. For many of you, this is not about reacting quickly, but about understanding how these rules affect everyday decisions like when to file, how to prepare documents, or what to expect next. This is a moment for clarity, not alarm. In this video, we will be looking at the USCIS rules that are now in effect as of January 2026, how they are influencing green card cases, visas, and work permits, and what these changes realistically mean for processing timelines and daily life for immigrants this year. If you find this video helpful, please hit the subscribe button, turn on notifications, and give it a like so you never miss important updates delivered straight to your smartphone. Now, let us get into the video. As these rules take effect, it is important to separate perception from reality. Not every rule change creates disruption, and not every update improves speed overnight. What matters most is how these rules alter day-to-day adjudication inside USCIS, how officers review files, how cases move between departments, and how applicants experience the process. One of the most significant impacts being felt in January 2026 involves case handling standards. USCIS has continued shifting toward more standardized adjudication, meaning officers are encouraged to rely more heavily on initial submissions and internal records, rather than issuing repeated requests for evidence when information is already available for applicants. This reinforces a critical reality: the quality and completeness of the first filing matter more than ever. A well-prepared application can now move more smoothly than one that depends on later clarification. Green card applicants are among the first to notice this change. Adjustment of status cases filed with complete medical exams, financial documentation, and supporting evidence are less likely to face extended back and forth. This does not eliminate scrutiny, but it can reduce unnecessary delays that previously added months to processing timelines. In January 2026, this approach is no longer optional, it is operational. Work permit processing is another area where new rules are now actively shaping outcomes. Employment authorization documents tied to pending green card applications remain a priority, but USCIS has tightened internal review steps to ensure eligibility alignment for applicants. This means clearer expectations, but also less flexibility when documentation is missing or outdated. The trade-off is predictability. When rules are applied consistently, fewer cases fall into prolonged limbo. These changes are especially important for families relying on dual-income households. A delayed work permit can ripple outward, affecting rent, healthcare, education, and emotional well-being. USCIS has acknowledged this reality in its operational guidance, even as it balances security and compliance requirements. January 2026 reflects that balancing act in practice. Visa-related processing has also been affected by rules now in force. While USCIS does not control overseas interviews directly, its coordination with the National Visa Center determines how quickly approved petitions move forward. Updated procedural guidance emphasizes cleaner handoffs between agencies, reducing the risk of file stalling after approval. For families waiting abroad, this can mean fewer unexplained gaps between petition approval and interview scheduling. Another area shaped by January 2026 rules involves biometric and background checks. USCIS has refined how long certain background clearances remain valid, reducing the need for repeated biometrics in some cases while maintaining security standards. This change may seem technical, but it can significantly affect processing timelines by eliminating redundant steps for applicants who have already completed checks within acceptable windows. At the same time, applicants should not assume that fewer steps mean less scrutiny. USCIS has been clear that efficiency does not equal leniency. Files are still reviewed carefully, and inconsistencies are addressed directly. The difference now lies in how decisively cases are handled once sufficient information is available. Another rule now active relates to communication standards. USCIS has expanded its use of standardized notices and online account updates. While this does not speed up approvals by itself, it reduces confusion. Applicants are less likely to wonder whether a case is lost or forgotten. In a system where silence has historically caused anxiety, clearer communication can make a meaningful difference. For employment-based applicants, January 2026 also brings clarity around portability and extension handling. USCIS has reinforced internal guidance on how job changes are evaluated during pending green card processes. This is especially relevant in a labor market where workers may need flexibility to maintain employment while waiting on long timelines. Clearer standards reduce fear-driven decision-making even if the process remains complex. Family-based applicants are watching how these rules affect interview scheduling and waiver usage. Early signals suggest a continued effort to reserve interviews for cases where they are truly needed rather than applying blanket requirements. When implemented consistently, this can ease pressure on field officers and reduce wait times for those who do need interviews. It is also important to understand the broader context in which these rules operate. Under the Trump administration, immigration policy remains a focal point of national debate. While USCIS rules focus on administration rather than politics, enforcement priorities and funding decisions shape how effectively these rules can be applied. Stability in rules does not automatically guarantee stability in outcomes. For many immigrants, January 2026 is about recalibration. Some are choosing to file now, confident that clearer standards reduce uncertainty. Others are taking time to prepare stronger applications, knowing that first impressions carry more weight under the current framework. Neither approach is wrong. What matters is informed decision-making. There is also an emotional dimension to these changes. After years of shifting guidance and sudden reversals, many applicants have grown skeptical of promises. January 2026 does not erase that skepticism. Instead, it offers a quieter signal, fewer surprises, clearer expectations, and a system attempting imperfectly to function more predictably. Looking ahead, these rules are likely to shape the rest of 2026 more through consistency than drama. The biggest benefit may not be faster approvals, but fewer unexplained pauses and less procedural confusion. For families and workers, that stability can be just as valuable as speed. Applicants should remain cautious about misinformation, especially online claims that exaggerate the impact of new rules. Changes are real, but they are measured. Staying grounded in official guidance and verified updates remains essential. As January continues, the true test will be implementation. Rules on paper matter less than how they are applied at service centers, field offices, and consulates. Early signs suggest a system trying to follow clearer lanes rather than constantly changing direction. For immigrants navigating 2026, the message is simple but important. Preparation matters. Accuracy matters. And understanding how rules affect your specific situation matters more than reacting to headlines. That is all we have for this bulletin. U.S. Immigration Info channel provides all necessary visa information and procedures for your U.S. immigration journey. It is important to understand the United States immigration processing steps, visa application requirements, processing times, forms, fees, and more. We will continue to provide all information about U.S. visitor visas, such as B1 and B2, work visas such as L1A, L1B, and H1B, student visas, green cards, immigrant visas, EB1, EB2, EB3, EB4, and EB5, and family immigrant visas. If you have not already, please subscribe to U.S. Immigration Info channel. Thank you for watching, and we will see you in the next video.